Businessman Hamilton Ndlovu has lodged an application to appeal the ruling where he was ordered to pay back 158 million rand that he received through irregular PPE contracts. A tender worth 172 million rand was awarded by the National Health Laboratory Service to Ndlovu and his associated companies. Joining me now is Special Tribunal spokesperson, Advocate Selby Makgotho. A very good morning to you. Thank you so much for your time. The flamboyant businessman is now appealing this recently, scathing ruling against him by the Special Tribunal. Perhaps let's start off with your reaction to that before we get into the crux of the matter.
Thank you very much, Sesimpo. Good morning to you and good morning to the viewers. Yes, indeed, we have received the papers to the effect that Mr. Hamilton Ndlovu is appealing the judgment that was granted by the Special Tribunal on the 7th of last month, of June rather, wherein it was directing him and his other associates to pay back to the amount of 158 million. That was pursuant to the awarding of the contract by the National Health Laboratory Services in the wake of the COVID-19 pandemic. The SIU and the National Health Laboratory Services are applicants in the matter. And we do not necessarily get surprised because this is a normal legal procedure where an aggrieved party, if perhaps is not happy with the ruling, the rules and the laws of this country do make provision for such a party to seek leave, and for the leave to be duly considered and legally processed. It will have to give compelling reasons as to why his views should be considered. If perhaps there are other points that perhaps were not considered in the initial ruling, he is at liberty to do so and give the Special Tribunal the reasons why he seeks this leave. And he has done a 17-page affidavit wherein he cites various reasons. So we are not necessarily surprised by this. We get such applications for leave to appeal on regular basis.
Perhaps bring us into some of the 17 reasons why he believes that this matter should now be re-looked at.
Well, in a nutshell, he challenges the constitutional validity of Section 172 that deals with the just and equitable remedy. Our approach to the Special Tribunal is that the remedy must actually fit the injury. So that is what he has issues with. And furthermore, he is of the view that there was a delay by the SIU in terms of instituting the review proceedings. And as part of the reasons for him seeking leave, he does indicate that such a delay had actually prejudiced him in the sense that he was not able to gather sufficient information to formulate his defense. Some of the documents apparently were seized by the police in the course of the investigations, and he apparently struggled to get those documents to prepare his defense. The other reason is that the Special Tribunal is not a court of law. It does not have a constitutional jurisdiction to preside on constitutional matters, and as such, he is of the view that a different court in this particular case, he is seeking to approach the full court, in the Gauteng division, and he is of the view that perhaps it would come to a different outcome.
So as he launches this appeal, how does it impact your efforts in recouping the state funds?
Well, now that there is an appealing process, it means the process of recouping the 158 million as well as dealing with the other preserved assets will now have to be put on hold pending the finalization of the leave procedure or outcome. So in the sense that now there is a leave, it means that the 158 million recovery process gets on hold up until there is a final and further determination on this particular outcome. This does not in any way affect our efforts as a Special Tribunal to do our judicial work, and we remain determined and resolute to do whatever it takes as long as we do that within the prescriptions of the law and of the Constitution.
And in doing your work, I mean, there is a substantial amount of money that we're talking here, as well as assets and luxury vehicles and all sorts of other matters attached to this money. Talk to us about what principle the Special Tribunal accepted on the monies and the deduction and the processes going forward as you recoup the funds and the assets.
Well, in this case, we are guided by the evidence that is presented before the Special Tribunal in the form of affidavits and any other documentary evidence that could assist the Special Tribunal to come to a fair, just, and equitable outcome. In the case of Mr. Ndlovu, pursuant to the investigations, findings were made at a preliminary investigative stage that in the form of allegations that led to the Special Tribunal to make a finding. It is upon those bases that in the end, when this finding was made, it was relying solely on the vehicles as purchased allegedly from the proceeds of unlawful and impugned contract, and other properties. I think there were about 4, if I remember well, properties or so. But that being the case, in a nutshell, the evidence that was led is the one that give rise to the Special Tribunal, not only in the case of Mr. Ndlovu, but in any other case. But also I need to indicate that we are observing a little bit of a trend as a Special Tribunal, where in terms of the constitutional validity, as I indicated earlier, maybe just to take you back a while, wherein I did indicate that this leave to appeal procedure regarding the jurisdiction of the Special Tribunal, we are pleased because now the matter is before the Constitutional Court and we are awaiting the outcome. If you recall briefly the Ledla matter, Ledla in the PPE procurement in Gauteng has taken the Special Tribunal up to the Constitutional Court, and we are waiting for the justices of the Constitutional Court to give further clarity and legal effect to this particular challenge. So that is where we are at the moment. And as and when the evidence is presented to the Special Tribunal, we will be able to decisively, in the form of constitutionally and legally speaking, provide judicial guidance in relation to the matter, guided solely by the Constitution and the need to recover the money as prescribed by the Act governing the Special Tribunal.
So in his appeal papers, Ndlovu and his companies are claiming that the tribunal misdirected its inquiry on the facts and thereby incorrectly assessed and determined the facts. How possible is that?
Well, no, he does indicate so that there are areas where there are areas of misdirections and so forth. But what he doesn't indicate is that based on the evidence, I think he's just touching at straws in the sense that, for instance, if you look at the areas wherein he speaks about the misdirection, it only relates to the delays that were there in the implementation of the review proceedings. And he does not apply that to any other law, much as I would not be knowledgeable as to what the outcome of the appeal is. But at face value, one could tell that Mr. Ndlovu is alleging that the Special Tribunal misdirected itself, but he does not give any specific constitutional or legislative misdirection in that regard. So that is what actually we do believe that during oral argument in the leave hearing, we will be able to hear exactly where we misdirected ourselves.
And in terms of fighting corruption and, setting a precedent, so to speak, when it comes to, justice prevailing. I mean, here we saw a very flamboyant businessman flashing his luxury homes and vehicles. What do you think the messaging is with the work of the SIU and the Special Tribunal in this matter?
Well, our Act is very, very clear that we are after the money, where indeed it is proven on a balance of probabilities that the money went into a person fraudulently or through misrepresentation or through any form of malfeasance. And in terms of the messaging, if you look at the Special Tribunal since inception, since 2019, we have been able to recover an estimated amount of 8.6 billion. And that is what came in the form of irregularities in terms of procurement. And this is the message that the special tribunal often sends out. I mean, yesterday you might have seen there was a review and setting aside of an application. There were 2 applications that were heard yesterday relating to the PPEs in Gauteng. And in most instances, the applications that come before the special tribunal do point to areas of irregularities, and we have so far succeeded in recovering the money, and where the monies have to be declared forfeit to the state, such orders have been made. Where repayments have had to be done, orders had to be made, and the parties had the responsibility then to implement and execute our orders. So far we have seen success, and we do believe that now that there is an extension of the special tribunal, we will be able to recover more.
And very lastly, before we let you go, I mean, you speak about these big strides that have been made, and very often we see the very same people creeping into the system again. I mean, what measures will be put in place to ensure that we don't see a return of the same figure, but with perhaps a different company?
Well, yeah, for instance, in the Hamilton Ndlovu matter and other matters relating to the PPE, orders were very, very clear. If you remember the case that we dealt with in the Free State relating to the procurement of PPEs, that it is now, the call was made, actually, the judge actually made a call that it is now high time that the relevant provisions of the Public Finance Management Act and other legislative as well as statutory provisions are now need to be seriously revisited, so that those who are found wanting should know that there are repercussions. You will remember that we have often said that it is the South African taxpayers, unfortunately, who are at the receiving end, because they are the ones whose monies are being taken by the people who to fund their own lifestyle for nefarious means, and that is what, at the end of the day, our country's jurisprudence is fighting for as we speak.
Very well. Let's leave it there for now. Thank you so much for your time. Special Tribunal spokesperson, Advocate Selby Makgotho, there speaking about the Hamilton Ndlovu matter.